Good morning, everyone, and welcome to our Q&A session. We've got a number of attendees that are still flowing into the room, have about 150 registered for this session today. So we'll just take a quick moment for everyone to get online, and then we will begin. While we are waiting, 2 points of Bar Association business for everyone. If you have not renewed your court ID yet, please do so online through the DCBA website. That can be done at dcba.org/court ID, or you'll see an image right when you go to the website with what we'll be talking about today, resumption of jury trials. We look forward to seeing more people in the courthouse, so please make sure you do have that ID renewed to avoid the lines at security. Second, would encourage everyone to take a look at the agenda for Mega Meeting. We are bringing back Mega Meeting in an online format, 2 Fridays of CLE across some great sessions. Chief Judge Popejoy will be delivering his first State of the Courthouse address. And we also look forward to a really good diversity session from the diversity manager from the ARDC and the new diversity director for the Supreme Court. That will be a very, very interesting session, along with several other webinars on a variety of topics. Again, all virtual on March 5th and March 12th in the afternoon. Information on that also on the DCBA website. So we just are looking at about 100 attendees, so let's go ahead and get rolling. It is my pleasure to introduce the presiding judge of the Law Division, the Honorable Robert Kleeman. Judge Kleeman.
Thank you, Robert, and I want to thank everybody for attending today. As you can see, I believe, a couple of the judges from the division have joined me as well. And at the outset, I want to thank the County Bar Association in general for their assistance. We've done this a few times during this pandemic, and it's proved to be an invaluable help in getting communication going between the bar and the bench. More importantly, and at a personal level, I want to thank Robert Rupp. He's been just a fantastic help in getting these things and others set up, and we really appreciate his help as well. And I want to thank all of you for coming. At the outset, Robert has reminded me to let everybody know the main purpose of this today is to afford all of you an opportunity to ask questions, and we'll do our best to answer them. There's a Q&A function at the bottom, I believe at the bottom of your screen. So we're going to ask you to use that, and we'll try to answer as many questions today as we can. With that, unless there's anything else, Robert, we'll get started. Okay. I know the big thing is resumption of jury trials, and I'm going to get right to that in just a moment. But before we get into that, as most of you know, our division is now requiring electronic orders. And the reason for that, there's a multitude of reasons for that. And again, I'll be happy to answer questions about that as we go forward. But just a couple of things as we're using those. If you're familiar with it, there are a number of different options you can use. And it's the request of the judiciary, if you can, to try to use the action order. The reason for that is fairly simple. You can always use a blank order, but when you use an action order, you put a date in, it gets entered automatically. You'll flag it if you enter a date that's excluded or a weekend. And there's no other clerk that has to put it in. You're cutting down the chances for error. It's simpler in a lot of respects from our end. So if you can, we encourage you to use the action orders when you can. And keep in mind, when you submit orders in advance, they have to be agreed. That includes even if there's a pro se litigant on the other side. We've had a number of instances brought to our attention where orders are submitted and it doesn't appear that they're fully agreed. So if you submit an order, you want it signed in advance. My position in the cases I hear is that you need to label it or in the email represent that it's agreed, and I'll be happy to sign it. Without it, I likely won't. So if there are any questions about e-orders, we'll be happy to try to answer those today. Then to get right down to it, as many of you or most of you probably know, we've been given the directive from the Chief Judge to resume jury trials beginning March 1st. A lot of time and effort's gone into getting that ready, but we do anticipate that that's going to be the case. Just to give everybody a little bit of an overview before we start taking questions, 2 courtrooms have been set aside for civil jury trials. One of them is on the 3rd floor, which I imagine most of you haven't had a chance to see, but it really is worth seeing if you get the opportunity. The jury box is set out so that everybody, jurors, attorneys, everybody is at a socially safe distance. And that courtroom is going to be dedicated for our division, so we can get going with that. And we're in the process of completing a reconfiguration in 2018, the arbitration courtroom. So that will be similarly constructed so that everybody will be socially distant, jurors included. The plan is at this point in time that we have 2 juries from the civil end from our division going every given week. And I just want to talk a little bit about what goes into that uh, as we go forward. The chief judge and our court administrator, Suzanne Armstrong, have been working, and I guess Judge Popejoy's predecessor, Judge Guerin, as well. I should mention that. They've worked very hard to get this done, and they've consulted with the health department, the DuPage County Health Department, and they support our resumption of jury trials with the procedures that are in place. And I'm not going to go through each and every one of them. We'd be here all afternoon. But just to give an idea, in addition to the remodeling that's gone on, we've reconfigured the deliberation rooms. Most conventional jury deliberation rooms couldn't accommodate 6 people, let alone 12. We've addressed that. We have appropriate rooms, 2 of them for our division. We've had to reconfigure the jury lounge. We have the people entering the courthouse, jurors included, have their temperature taken, whether they know it or not, as they come in. And anybody who has above, I think it's 100.3, is told to go back. We are screening the jurors, asking them questions about their exposure, things like that, and taking the appropriate steps. And again, I can go through all that's been done to try to make sure that we can represent that with the approval, with the support of the health department, we believe we can resume jury trials in a safe manner. I've touched on the fact that we have 2 trials only for the entire division, and as you can imagine, there's a backlog has been building for months. We started this in January when we intended to resume trials in January, and then the numbers require us to push that back a couple of months. But the procedure that we're going to employ in terms of getting cases to trial is that on a monthly basis, all of the judges in the law division are going to meet. They're going to bring the cases they have set for trial in a given month. We did this in January for March, and we'll do it this month for April. And we're going to sit around and in a meeting, and we're going to prioritize the cases that are set for trial in any given month. No one factor is going to be controlling, but we take into account the age of the case, the amount in controversy, the number of times it's been up for trial, ages of the parties, the involvement of experts. Again, you could imagine the rest of it, but we will discuss that, and then we'll come away with, on any given week, a list. Your number, this case is number 1, 2, all the way down. And then what our intention is, I set my final trial conferences on Thursdays. I'm encouraging the other judges in the division to do likewise, although it varies from judge to judge. But on Thursday, whoever's got the case that's number 1, that's answering ready. That will go the following Monday in one of the 2 available rooms. Whichever one is number 2, similarly, will go in one of the 2 available rooms. If those cases settle or a judge grants a motion to continue, the number 3 will bump up and the like. Our intention is to make sure that everybody that has a case set for trial on a Monday will know by noon the Thursday before if in fact they are going or if they're going to be continued due to a limited number of courtrooms that are available. And the topic of continuances, I just want to touch on that. As always, obviously, if there's a motion to continue, present that to your judge, and it will be addressed. But the one message that the chief judge has impressed upon me, and I've tried to impress upon the judges in the division, is that just saying that it's, we'd rather do it in another time without a statutory basis to continue likely will not succeed in getting a case continued. I don't want to put too fine a point on it, but we've spent a lot of time and taxpayer dollars making these rooms safe to be used for jury trials, and use them for jury trials we're going to do as long as we're all convinced, and with the health department's guidance, that it can be done safely, and we believe we can. So we are going to probably be holding cases to trial unless there's an appropriate motion to continue. Just want to make sure before we move on there's another question that gets asked all the time, is about witnesses testifying via Zoom. And that is an option. I've done bench trials during the pandemic. I know other judges in the division have as well. And Zoom is an option. I've had witnesses testify via Zoom, but I don't want anyone to think that it's just an automatic procedure. As you can imagine, if you give it any thought, there's all sorts of potential problems with a witness testifying via Zoom. Start listing them rapidly if you want to. If you have a witness and you're contemplating making that request, I would urge you to bring that to your trial judge's attention as soon as possible. From my end, personally, if a case was, or a witness testified by an evidence depth, that solves so many potential problems, as opposed to somebody testifying from some remote location where we don't have control over the electronics and all the like in front of a jury. I think has potential problems. Not that they can't be solved, but if you do want to have somebody testify via Zoom, I think preparation, planning and notice to everybody, including your judge, is the key. Beyond that, I know there's issues about technology. We're updating the technology in the courtrooms. I'm hoping it's all done by March 1st, but the ability to have TV monitors that's going up in my courtroom, or an advocate can just plug in their laptop and it can be shown on all the monitors throughout the room, is in the works, but I'll have to keep you posted on that. It's not done yet. It'll hopefully be done by March 1st in the rooms we're using, but fingers crossed. With that, and I'm just looking, if anybody has anything that I've missed in terms of the opening remarks, my colleagues there, please let me know. Otherwise, I think the purpose of this thing, the main point of it, is to open it up for questions. Hearing nothing else, Robert, if you have any questions, we'll be happy to try to answer them.
For sure, Judge. We have had a few questions roll in. We'll just sort of take them in order here. Will the Civil Division continue to use Zoom for status conferences and hearings on motions once this pandemic subsides?
Yeah, that question comes up, and the answer, as far as I'm concerned, is yes. My personal opinion is that Zoom is here to stay. I would be surprised if it's otherwise. I do get the question about opening up for statuses and things in the short term, and there are no plans to do that right now, just so everybody's aware. The approach is to try to keep foot traffic to a minimum, especially with resumption of jury trials. We're going to have jurors coming in by the dozens, if not hundreds, on any given day. So we're not going to do that in the short term, but in the long term, I think it's going to be, Zoom is going to be a part of it. And in keeping with the technology upgrades that we're getting, my room is getting it done now. The idea behind this is that somebody could be here appearing on a status or motion in person. Somebody could be appearing via Zoom, and we wouldn't miss a beat. So the short answer is yes, I think it's going to be here indefinitely.
Sort of a safety question. As foot traffic increases and more people are in the courthouse, will expanded sanitation practices, particularly in the washrooms and the garage, be implemented?
I'm not sure exactly what's being asked there. I know that for those of you who've been in the courthouse, we do have sanitization stands all over the place, and I know that arrangements are made to make sure that there's masking and things like that available for jurors. But in terms of what would go on in the restrooms in the garage, I don't know that I'm the person to answer. I'm not 100% certain what's being asked. So the short answer is, I guess I don't know.
What is the actual number of civil trials in the backlog?
I don't know that I have a number to give you right now. I know that my caseload has probably increased, just my number of pending cases, if I had to guess, has probably increased by about 20% since this pandemic started. How many of those are ready to go to trial, I guess we could debate about, but I don't know if we sent around the statistics fairly recently, and I think most of the courtrooms, at least the L courtrooms, have a similar thing. So our case numbers are up. I'm absolutely convinced that that's almost entirely due to not being able to try cases. So I don't know in terms of exactly what cases are ready to go to trial that haven't been able to go. I don't know how to answer that, but our caseloads are up by about 20%.
If you do not get through the monthly list of cases in a given month, do they carry over to the next month, or do they get a new trial date?
No, what I contemplate, and again, I want to emphasize too that all of this stuff is subject to change, for a lot of different reasons. But the current plan is that if you're up for trial, you're not one of the two that go, we would give you a future trial date. That's what we're planning. And again, some of this stuff may change as we go. We'll see how it works out, but that's the plan right now, that if you're number 3 and you're told you're not going on Monday, your judge would help you select another date months in the future.
How do you see jury selection working?
Well, that's a great question, and one that I know the judges in the division have spent a lot of time talking about how this is going to go. And there's been talk with, I think the Supreme Court has put out some rules regarding virtual jury selection, which we're not going to employ at this particular time. But we've got jurors coming in that we think will be sufficient to cover 2 jury trials, and then we're going to bring them up. My practice, and I've been asked this question by the judges are charged with making sure that everyone in their courtroom, everyone associated with a case, behaves safely. Masks are required both by common sense and by Supreme Court rule in the courthouse. Social distancing, the sheriff's office is told to help us enforce social distancing. So when you say jury selection is going to go, I think it's going to go fairly closely to what it normally does. My practice, when I did a bench trial, I think I would employ the same practice during jury selection, is that I direct a witness to take off their mask when they're being examined. Unless somebody tells me otherwise, I think I would do that with a juror while they're being examined. No one would be within 6 feet of them. They would take their masks off so we could hear and we could observe them. But other than that, I think it would go relatively closely to what happened in the past. I don't know if that answers your question, but.
And I think just sort of to follow along, what about, so certainly the potential juror witnesses, what about the attorneys? Masking requirements for attorneys?
Again, I hesitate to, I've been asked this by some of my colleagues. I'm not telling somebody how to run their room other than to tell them they have to comply with CDC guidelines. So what I've done in my bench trials, and I've told all my colleagues this, and I recommend it because it worked, is I took the time before the trial started, a bench trial, and set up the counsel tables, the podium, so that everybody, the witness, would be at an appropriate social distance place. I think we'll have no trouble accomplishing that same thing with these reconfigured courtrooms. My practice was I let the attorneys, if they wished to take their masks off at their counsel table, whether they wanted to keep them, was between them and their partner. But I could imagine trying to conduct a trial with a partner at a table with a mask on could be difficult, but that's up to them. If the attorney was at the podium, they could take their mask off. I've never been a big fan of telling attorneys you have to stand here, you have to stand there. I normally don't do it, but during this pandemic, my policy was if you wish to have your mask off and you're in the courtroom, the courthouse, I guess I could say, you're either at your counsel table or you're at the podium. If you wish to step away from that podium for whatever reason, you need to put your mask back on. So it's a little cumbersome. I don't like to have to tell attorneys that they have to be confined to that space. But I've given safety rules and like that was like practice. Again, I normally don't tell attorneys they have to ask to approach a witness, just approach. Unfortunately, now I do tell them you have to ask to approach so that everybody, the witness, the attorney, mask up. If you need to approach for some reason, you can do that. And that's something else too, as we go forward. I just would ask attorneys if their trial date's approaching, give that some thought. I'm hoping we have the ability with technology that you can show exhibits and the like in all these courtrooms without approaching, but if there's something you have to approach, we need to give that some thought because frequently approaching and exchanging documents may become problematic in the days of the pandemic. But bottom line is, if you want to take your mask off to do examinations or consult with a colleague, in my practice is you may, but you'll be limited as to where you can do that.
On the issue of the tables and counsel tables, what about cases with multiple defendants and multiple defense attorneys? How big are the counsel tables for trial, and is there a limit to how many attorneys could be sitting in the counsel table in these new rooms?
We have no limit that we've talked about, but part of the reason we've selected these, well, one room was made. I mean, it didn't exist a year ago, and the other one we're reconfiguring is because we believe, particularly in the one on the third floor, we could get 3 and maybe as many as 4 counsel tables. Now, I understand that sometimes there's more than 1 or 2 attorneys on a case. People want to sit at a counsel table. I don't know that that I can tell you exactly how many people could sit at a counsel table up there. I can't imagine it could be more than 2. But if you're going to sit at a counsel table, you're going to be within 6 feet, and there's just no way of getting around that. What I've done in my bench trials is I required the litigants, the parties themselves, to sit in the gallery behind that. If they need to consult, they can go back and forth, but I didn't want to have too many people in the wall of the courtroom. But again, if you want to sit next to your co-counsel at counsel table, I leave it up to the attorneys to decide if they want to do that or not. But the one upstairs, I'm confident we can get as many as 4 counsel tables safely in the wall of that courtroom. Certainly 3.
Great. If you have a chancery case that has a count or counts requiring a jury trial, how will that type of case be handled?
Again, some of the stuff we're learning as we go. We've touched on this. I've talked to Judge Fullerton and told him that if anybody in his division has a jury that they have set and they're interested in having one of these courtrooms, to just let us know. Obviously, they have to be given appropriate priority as well. That doesn't happen a lot. He's assured me that they would let me know. I have not heard from him. I will follow up about that, but that judge will just have to, the chancery judge, let us know and be a part of that process where we set priorities for any given week, and those will have to go as well, given the fact that we've only got 2 civil courtrooms to deal with.
If a case currently scheduled for Zoom bench trial in April Will it be automatically rescheduled for in-person, or should we file a motion?
I don't know about Zoom bench trials because I haven't scheduled one. Maybe some of the other judges in the division set stuff for Zoom bench trials, but whether it goes a witness or part of it or all of it goes via Zoom or in person is up to um, the individual judge. I wouldn't presume to interfere with that call. Each judge needs to make that call based upon his or her discretion. But the one thing I guess the chief did ask me to talk about, there was an administrative order saying that in-person bench trials will resume on a given date. And I guess to the extent I'm responsible for that, I didn't mean to cause any confusion. We have the ability to resume in-person bench trials March 1st at each judge's discretion. Whether they go whole or in part via Zoom is up to each individual judge. And I would just urge you to, if you have a need to do something via Zoom, let your judge know as soon as you can so all the problems can be addressed.
I'm going to lump a few questions here together from different people because they all sort of have the same tone and theme, and that is assuring potential jurors that the procedures that are going in place are safe. What's going on for public education? Is there any effort to, perhaps, weed out, if you will, a juror who just, would not, be comfortable coming into the courtroom in this situation? That seems to be a fairly common concern.
Well, and that's a question we've spent a fair amount of time. I know others in other parts of the judiciary, that's their focus down in the jury commission. Sue Makovic, who runs things down there, has spent a lot of time along with the chief judge and the court administrator, but they are advised of the precautions that we're taking. I'm looking at the sheet that goes out to them right now to let them know what we do to make sure that it's safe. But in terms of if somebody comes in, again, if you go back to pre-pandemic days, if somebody gets a jury summons and they say for whatever reason, I want to have that postponed, I'm in school, it's not a good week for me, they normally get, I think it's 1 or 2 times when they can just do that, no questions asked. And obviously that's going to continue. Right now, as I understand it, if somebody's over the age of 65 and they say they're not comfortable coming in, they affirmatively say that to us, they will be excused, as I understand it. I also am given to understand that a similar process would be employed for somebody who's again, there's documentation and steps that the jury commission employs that I don't want to try to tell you what they are because I'll make a mistake and get it inaccurately. But if somebody's a frontline healthcare worker and they say, I'm asking to be excused, my understanding is they will be excused so they can attend to their business in this pandemic. But all those things beyond that, in terms of what processes, we will be prepared to talk about those at the final trial conference. But yes, there's a number of those processes in place. I can try to get into all of them. I have some of these in front of us. I mean, disinfect the rooms. They have actually, I've seen it, I guess they're called robots, but they go through using ultraviolet lights when I was doing my bench trial at night, and they come in here and disinfect the room. So a lot of those things are in place. The jurors will be notified about those steps, the screening that takes place, what we're doing to make sure that it's safe. And beyond that, I don't know if that answers the question. I hope it does. But yes, they will be told coming in, I think in advance as well, that those are the steps we're employing to make sure that they're safe while they're here.
Great. Will attorneys be told if their case is number 1, 2, 3, 4, etc., 60 days in advance after the law division judges meet and make those decisions?
At this point in time, I'm disinclined to do that. I would welcome any input from anybody, but the reason I don't want to do that is just because if I tell you that you're number 3, number 4, that can change in 60 days. I mean, I know Judge Kappas came to me. We had a case set in March, and it was number 1, and you tell them, when I'm status date, and again, Angela, you tell me if I'm not representing this correctly, but you let them know you're up and you're number 1 and you're going to be expected to go absent a motion to continue. And as sometimes happens, that case settled. And so everything gets bumped up. So the current plan is no. I mean, I'm open to discussing that, but it can change so much in 60 days. My concern is that telling you you're number 4 may be giving you a false sense of the likelihood of you going.
2 questions that kind of line up together. How many jurors will be brought up for a panel, and will the court select more alternates in the event that a juror would be diagnosed with COVID?
Yeah, I hope that doesn't happen. But yeah, we will be prepared to pick alternates. The rooms are designed to pick alternates. I don't know that there's plans to pick more than 2. And you have to keep in mind that while we're cutting our teeth in March, We have picked jurors in criminal cases in the past, and I've got the feedback from those jurors. Things have gone relatively well, and I'm hopeful that it'll continue. So yes, we'll pick alternates. And I don't know that it'd be 4, but we will be prepared to pick them. And how many or whatever, I'm going to leave to each judge to sort out with the litigants in their case. One thing, I think you asked how many be brought up. Normally for a non-medical malpractice case, we bring up 30. For a medical malpractice case, our practice has been to bring up 50. That's still going to happen. If somebody at a final trial conference thinks there's a need to adjust those numbers for some reason, we can talk about that, but that's the current plan. And I do think it bears pointing out, thinking about all this, that if you're trying a case, just pick any old case, whatever it is, a garden variety auto accident case that would take 3 days. I think the attorneys need to be prepared for the fact that a 3-day jury is likely not going to take 4, maybe 5. Things are going to go slower. So it reminded me when you asked about bringing jurors up that they're going to bring jurors up in groups. They're not going to bring 14 jurors up. Jury selection. They're not going to bring 30 or 50 jurors up all at once. It can't be done safely. Breaks during a trial. We can't just stick 12 or 14 people in a conventional jury room and let them, have their morning break. We have to split them up and take them around. So everything is just going to take that much longer. And I thought that was a good opportunity to point that out. And if you're planning, I don't think that. I think things will go a little bit more slowly than they normally would because of safety precautions.
Will the public be allowed to attend and observe civil trials? Clients, insurance adjusters, other attorneys. I would add to that, as someone else said, would that access be available now on Zoom for observation?
Right now, I mean, if something's going on Zoom, I mean, obviously the public could do that. If I was doing a trial and nothing was going on Zoom, there would be no Zoom access that I'm aware of. I guess I could take a look at that, whether they should be made accessible by Zoom, but I have questions. I hadn't really thought about that. I have concerns about that as I sit here right now, but the public would have access. Obviously, we're obligated by law to make sure that these courtrooms are open to the public. The only restriction on that would be making sure that there's seats available. For instance, in the courtrooms that we're going to get ready to do jury trials, if we have 30 jurors in a room, there isn't going to be any seats for anybody else until those clear out and we start using some of those jurors. So yes, with the understanding that there's going to be limited seating that can be accomplished safely. I guess that's the best answer I can give you.
So there's a number of questions sort of about the structure of the room itself that I think could easily be summed up into, is there any way for the bar to get a look at what this room looks like?
The courthouse is open. I hesitate to call people into the courthouse. We're trying to keep foot traffic to a minimum. And I can talk to the chief judge and the chief judge's office about making those arrangements, and maybe we could do something through the Bar Association, Robert, to accomplish that. What I would tell you is that if it is going, if your case is going, and I've made this clear to the judges, we need to make sure that you, the practitioners, get an opportunity to see that courtroom as soon as practicable when it's going. But the short answer is yes. I just hesitate to tell you exactly how we're going to do that. I will promise you that I'll talk to the chief judge, and if it's all right, Robert, I'm going to consult with you about how best to go about that, so I don't do something that's going to create foot traffic that our chief judge's office isn't ready for. But yes, we should be able to accommodate that if somebody needs to take a look at that.
Well, and also let me just jump in real quick. Also on that issue, at the final pretrial, the anticipation is that the trial judge, when we're doing jury instructions, motions in limine, et cetera, will take the lawyers up there one way or another, especially to 3011. 2018 shouldn't be a problem. 2018 is like the rest of the courtrooms down here, but 3011, if you're having a trial going in that new courtroom, you will get a chance to see it at least at the final pretrial, if not sooner.
Let's see, another question on jury. So won't the juror profile be adversely affected by the reasons the court outlined to excuse potential jurors?
Won't the jury profile be adversely affected? I'm not certain I understand the question, but if your question is about asking the jurors about concerns regarding COVID and the like, I don't know if that's exactly the question. I invite my colleagues, if I'm misunderstanding the question, to jump in. But we are going to address what questions get asked of them. I'm going to leave that up to each judge. We've talked about that, but I personally, we're going to screen them. I'm inclined to say if you have questions that you want to ask them about their concerns about COVID, I would ask those questions, and I'll deal with that with the attorneys on the final trial conference. I don't know that I need to dive into it right now, but I think that can be a very sensitive topic that if it's going to get asked, needs to be asked neutrally to get at their concerns and their feelings, as opposed to allowing somebody to, ask a question in more of a loaded fashion. But you would be, I believe, entitled to ask some questions, have the jurors ask questions. How those jurors are asked those questions, I guess, is up to each individual judge.
Given that breaks will need to be staggered for jury trials because of the size of the old jury rooms, how will deliberations be accommodated? Or is there a new larger jury deliberation?
Yeah, there are, and with that, there are solutions and problems, but no, there are two jury rooms. And again, I'm told, had architects, the county building folks measure all this out, and the jury rooms that are available near 3011, there's two of them for our division. They can accommodate 12 people deliberating safely. So that's not an issue. One other thing I need to touch on is we're hoping to resume 6-person jury trials with small claims, and I guess it can happen in ARB once in a while. They're going to have to use the two that we have available if they're available in a given week for the month of March and April. We hope to have a 6-person jury room set up for that purpose as well. But yes, we have jury rooms. We try to get a third one so we can get 6-person juries going at the same time, but they can be done safely. And I'm just telling you, you could imagine if we need to take breaks, that has to be staggered out, because we can't have everybody just crowding into a jury room. And we talk to the sheriff's office about taking them to 2 different rooms, and individually making sure that they have an opportunity to use the facilities or what have you, make a phone call. But there are jury rooms that will accommodate that.
Great. How much notice can be expected as to where a specific trial has fallen on the roster?
So can you say it again for me, Robert? I apologize.
So if 60 days notice of our case position is not, where you fall on the list, how much notice can be expected?
Well, I mean, you've set for trial, and the plan right now is that on the Thursday before, you'll know if you're ready, if you're going to be going the following day. Before that, it's just difficult to tell you where you stand on all that, and we'll continue to talk about it. But the plan right now is you're up for trial. You're expected to be ready to go on the Thursday before, and we'll figure out who we can accommodate and who we cannot. That's the current plan.
Okay. How will sidebars be handled, or what happens if a potential juror needs to be questioned outside the presence of the rest of the jury?
In 3011, I know there's a room that's being wired outside the courtroom that can accommodate, we were trying to figure this out, can accommodate at least 3 or 4 people. It might be a little tricky, but we will take a look at that. I mean, that should be able to get it done. There are other facilities outside there. I know we have CourtSmart. If we don't have a live court reporter, we have to have it recorded in some fashion. There's ways we can talk about that. I don't know if it's Judge Rome, who's not available today, suggested that we have a computer device available and we can record it that fashion. There are some options, but we are prepared to deal with it, depending on whether or not there's a live court reporter, which will happen in some cases, or CourtSmart. It will depend on how we handle it, but we are prepared to deal with sidebars. And in 2018, I don't believe it'll be an issue at all, because there's, again, if there's 4 or 5 people at the jury, the sidebar, there's jury rooms on the 2nd floor that can accommodate those sidebars. We just have to figure out whether it's a court reporter or recording how to handle it, and we're ready to do that.
What will the plan be if a juror or counsel tests positive during the pendency of a trial?
I apologize, Robert. I'm having a little, I got to turn my microphone up. It's my fault.
Sure. What will the plan be if a juror or counsel tests positive during the pendency of a trial?
Well, I guess we'll have to take that one at a time, but it would seem to me that that would be an enormous problem that may well result in a mistrial. In terms of the health concerns, I probably would notify somebody who would give you better advice than I as to what we do and how best we do what we can to make sure everybody's safe. But if that were to happen, obviously that would be something that would likely cause a mistrial, I would think, and notify the health experts and get their advice.
Great. Well, that rounds out the questions that we have thus far. I will say, there was quite a bit of comments of that it, would be very good if we can find some way to either a video tour or something to, give folks a look at the new rooms. And certainly, we're happy to help you with that any way you see. back.
No, and I appreciate that. I will let you know right now, I fully intend to contact the chief judge's office and see how best, whether it's a video tour, we get through the bar, but I think that's a fair point, and I want to make sure we do it, and we do it as safely as we can. To my colleagues up there, does anybody have anything that I overlooked or that you want to add or emphasize?
Yeah,
Dave?
let me just add a brief point. I want to suggest to the lawyers that appear in front of us regularly, if you have concerns about your cases, let us know sooner as opposed to later. We couldn't cover everything today. I know there were some other questions out there. The next time you're in front of one of us, just go ahead and ask, because we're flying blind just like you guys are. We're trying to do our best to accommodate everybody, and we're very aware of the concerns of the Bar Association, the litigants, as well as our own concerns. So please, if you have suggestions, don't be afraid to ask. And if you have anything you want to tell us about, just let us know. We're trying to accommodate everybody if we can.
And if I could piggyback on that just a little bit, the one thing I meant to say, and I think I neglected, is if you have questions, comments, suggestions, my assistant, Emily Rompus, she's got, send her an email or whatever, let me know. We'll be happy to take a look at it. We've spent a great deal of time trying to anticipate what problems we foresee happening. And the one thing we keep coming back to is there are going to be problems we didn't think of. And you may think of them in advance and help us solve them. So if you have suggestions or comments or questions, if I can answer them, please send us an email and we'll do our best to get back to you. Anything else, Dave? Angelo? All right, and Brian Chapman. All right. Robert, that's, unless there's other questions, we're happy to answer them, but that's all we had for right now.
That's great. Well, thank you, Judge Kleeman, all the other judges. We're always happy to host these, and a recording of this session will be available later this afternoon on the DCBA website. For if you have any colleagues that missed the live performance, they can certainly catch up on all of these issues through the recording. So thank you again, Your Honors, and thank you to all of our members who are online, and have a good afternoon.
Thank you.